This is the meeting of the Oregon Criminal Justice Commission. Thank you all for your patience. Our first order of business will be to roll call.
Commissioner Beach. Should we make sure that they're able to hear us?
Present.
Okay.
I am here. My apologies.
All good.
Commissioner Freeman,
I am here.
Commissioner Herndon, Commissioner Harris,
I'm here.
Representative Lewis, Commissioner Lehman,
Here.
Commissioner McPherson,
Here.
Commissioner Miller,
I'm here.
Commissioner Norton,
Commissioner Norton.
Yes, I'm here. I'm sorry.
Thank you. Commissioner Perosa,
Here.
Representative Krasonsky, and Chair Solomon.
I'm here. And do we have anybody signed up for public comment?
We do not. Nope.
Okay, well, we're going to go ahead and get started. But first, I just want to publicly thank Commissioner Harris and the wonderful people here in Deschutes County who have hosted us today. It's always a treat for us as commissioners to get out and see the work on the ground. And it was powerful, the presentations, the stabilization center. It certainly gives me food for thought, and just really appreciate the warm welcome and the hosting of today's meeting. We have a couple of items on the agenda today. It shouldn't be a super long agenda. First item is we're going to hear from our Sentencing Guideline Committee about some sentencing guideline changes. And I believe, Rachel, you're going to tee that up for us.
Yes. Let me share this.
And while you're doing that, I just want to thank Commissioner Perosa, Commissioner Miller, and Commissioner McPherson for taking the time to serve on this committee. Above and beyond the call of duty.
Yes, good afternoon. Chair Solomon, for the record. My name is Rachel MacArthur. I'm staff here at CJC. And today we're going to go over some recommendations from our Sentencing Guidelines Subcommittee. And to echo Chair Solomon, this was a great process, this subcommittee. First time we have done this for this, and it's on my end, it was fantastic. The commissioners showed up so well prepared. The meetings were very smooth for a pretty difficult and needed subject. And so I just appreciate your all's effort. Also, just want to say this presentation is very text heavy. And you all did get a document with a memo from staff with all of this information. So please refer to that as we go through this. It is text heavy just because of the nature of the subject matter. I felt it was necessary to keep detail on here just for the public to be able to see this decision making. So I do apologize. I'm not going to read everything on the slide. We'll just kind of summarize. And then if you all have any additional questions, obviously feel free to ask me, but we do have the subcommittee members that are here that are also willing to answer questions. So just wanted to note that it's a little bit different of a presentation than what is usually brought before you all. So just real quickly, this is the background of why we are here today. This was actually one of the first things that the Criminal Justice Commission was tasked in doing, was sentencing, the sentencing guidelines and grid modifications. And so that is why we are here. We did this these new crimes will cover 25, 26, the legislative sessions for and so we try to come every year, sometimes just given timing, the types of crimes, the amount of new crimes that come out of session. It's either every year or every other year, but this is why we are here. This is the sentencing guideline grid. I do like to go over this. I know this is something that I think is referred to quite a bit. I don't know how often people see this, but we do use, Oregon uses a presumptive sentencing grid. And so just to kind of orient you, A through I is where an individual's history is calculated, with A being the most serious. So then it goes backwards. 1 through 11 is the seriousness ranking of an offense, with 11 being the most serious. The yellow boxes are the presumptive prison sentences in months. And then the green, blue, and magenta are presumptive local control sentences in months. Were there any questions about that before? Sorry, I clicked too. Any questions about how to read this or what this is? This is just an overview. Again, I won't go into this. This is the where we kind of the commission's role in rule and why we are here today. Really the big thing, the big takeaway this subcommittee in particular worked on is that last point with the change in rank of seriousness, or to rank them in crime seriousness, or to designate them as a person crime. There are two levels of crime seriousness scale. One deals with misdemeanors, the other one deals with felonies. Same thing as person crime designation. We then will, as a result of this outcome today, we'll then put this in rule. So this will be something with your all's approval of these recommendations or any sort of changes that you want to make today. We'll then go in and go through the rulemaking process and make these adjustments in these OARs. Okay, so to start, again, I apologize, this is text heavy. You all do have a document that is very similar in this if you do want to follow along. And please, if you do have any sort of questions as we go through these, don't feel free to interrupt for clarification. So Senate Bill 236, this is the unlawful possession of fentanyl. This particular new crime was an unclassified misdemeanor. And the subcommittee recommendation was for no crime category and no person crime designation, which was very much mirrored the established discretion to statute covering other types of drugs. So hydrocodone, methadone, oxycodone, heroin, ecstasy, cocaine. And then also all of these were also not designated as person crimes. And so that was the recommendation. I'm also going to kind of pause between these to see if there's any questions. You have any, just want to make sure you all get the information correctly. So again, in Senate Bill 236, this is another unlawful possession of fentanyl. This is a Class A misdemeanor. Again, the subcommittee recommendation was no crime category and no person crime. For the same reasons as the previous one, it did mirror the statute covering very similar drugs and crimes as it relates to those drugs, and there was no classified person crime as well. Again, unlawful possession of fentanyl, the difference being this is a Class C felony. And so the subcommittee recommendation for this is that it's a crime category 6, no person crime designation for this. And again, it mirrors all the other possession statutes that are Class C felonies on the crime seriousness scale.
And so is this one a Class C because of weight, or why is one misdemeanor and the other a felony for the same?
Because it's either a substantial quantity, meaning that there's, I think for fentanyl, it's 5 grams or more,
Okay, so it is,
or a commercial drug offense.
got it. That makes sense.
Were there any other questions? Sorry on that
No,
one.
no, that's, understand why.
This one for Senate Bill 236, the unlawful delivery of fentanyl. This is a Class B felony. The subcommittee recommendation, if you look at this one, this goes through different crime categories depending on circumstance. I'm not going to read through these, but I will pause for you all to get a chance to kind of look through these. It does mirror the established direction in statutes covering very similar Class B felonies of different types of drugs. And all of these are also not designated as person crimes.
Do you know off the top of your head how many doses 100 grams of fentanyl might be?
I actually don't know that.
It's like thousands, right?
It's a lot.
Yeah, that's a lot of fentanyl.
Yeah, usually 0.2 of a gram is an average user dose. Yeah. We go through multiple doses a day. You'd have to dose every 2 to 3 hours.
How many grams?
0.2.
0.2, okay.
It's average. 0.1 to about 0.5 is extreme use. That's relatively rare.
Thank you.
Any questions regarding this scale of crime category designations? Okay. Unlawful delivery of fentanyl. This is a Class A felony. And Chair Solomon, the difference between this one, if you look at the summary, it says it's a Class A felony if the delivery is to a person under 18 years of age. And so that's the difference between the previous one. This would be a crime category 8, no person crime designation. And the reason for the recommendation is it gives a judge the option to potentially give an offender more time up to the statutory maximum. Delivery of fentanyl within 1,000 feet of a school. This is a Class A felony. And the recommendation is a crime category 8, no person crime designation. This also mirrors kind of the established direction of statutes with the unlawful delivery within 1,000 feet of other drugs as well. And all of those are designated crime category 8, and they're not classified as person crimes. The manufacturer of fentanyl, this is a felony Class B. Again, this one has a scale for, with the subcommittee recommendation has kind of that scale of crime seriousness depending on circumstance, goes all the way through to crime category 10. There is a recommendation for no person crime. This also mirrors previous statutes, and all of those statutes are not classified as person crimes. Any questions on any of these, the crime series rankings? The manufacture of fentanyl within 1,000 feet of a school. This is a Class A felony. A crime category 8 and no person crime. Again, this mirrors already established statutes with unlawful delivery within 1,000 feet of a school or different drugs as well. And they are also not classified as a person crime. Okay, Senate Bill 243, this is the unlawful transport or manufacture or transfer of a rapid fire activator. This is a Class C felony. And the subcommittee recommendation is a crime category 6 with a no person crime. The reason for the recommendation is that it's aligned with the established direction to statutes on the manufacture, importation or sale transfer of detectable or undetectable firearms. So it kind of mirrors that, aligns with that. And then all of these statutes are at crime category 6, and they're not classified as person crimes. Anybody have any questions on this one? Possession of a rapid fire activator. This is a misdemeanor, a Class A misdemeanor. No crime category and no person crime. This is a recommendation by the subcommittee. And aligned with established statutes on very similar, like the manufacture, importation, or sale, transfer of a detectable, undetectable firearm. So very similar to those. It aligns with that. And then all of those are not classified as far as crime seriousness categories, and they're also not classified as person crimes. So Senate Bill 1125, the intentional interference of an unmanned aircraft system with law enforcement or emergency response. This is a Class C felony. The recommendation is a crime category 6 and a no person crime. And the reason is that this was already established in the bill. And so subcommittee went with what was in the bill. The same bill. This is a little bit different. It's a Class A felony, and it qualifies as a Class A felony if the person possesses or controls an unmanned aircraft system and knowingly, intentionally, or recklessly causes death or serious physical injury to another person. So a little bit different language there. So the subcommittee recommendation is the crime category 8 and a person crime. And crime category was already established in the bill. And the dangerous weapon in the operation causing physical injury to another rises this one to the level of a person crime. That is the reasoning for this recommendation. Any questions on this? So HB 3819, this is violation of massage license or permit requirements with a prior conviction. This is a Class C felony. The recommendation is a crime category 2 and no person crime. And this, the reasoning for this is that it aligned with other licensing violation crimes. Senate Bill 840, this is false swearing. It's a misdemeanor, a Class A misdemeanor. The subcommittee recommendation was no crime category, no person crime. And the reason why is it just was simply a modification of the statute. And it didn't indicate the need for a classification of a crime category or the designation of a person crime. Senate Bill 170, crime of assault in the 4th degree. This is a Class C felony. This one, the recommendation, both crime category and person crime were already established in rule. And so the recommendation was to continue with that simply because it aligned with other assault felony crimes. And then same, except for this one is elevated to a Class C felony. And I believe the difference here is that they have 2 previous convictions. And so the recommendation was crime category 6 and a person crime. Again, these are both already established in rule and aligned with other assault felony crimes. And so recommendation was to continue with that, what has already been established in rule.
And just to get clarity on the summary part,
committed against a victim who was performing official duties as part of the victim's employment. Does it matter what type of employment? It's any person who's working in a job that's a victim, or is there a particular employment positions that this is applying to? I think about like where I think some of the site cover like nurses working in hospital setting that are being assaulted by patients, or other police officers, or but is it? I mean, that's pretty broad.
It is her.
Any person working.
It's an expansion of an already existing, I think it was assault 3 actually, that wherein EMTs and one other category of people, if you assaulted them in the course of their duties, you can be prosecuted for a Class C felony.
Okay.
It has a crime seriousness level of 6.
Okay.
At that. This is kind of an extension of that, but I read it to, and maybe Carl or Amy, you can chime in from what you recall. I don't have the bill in front of me, but it seems to be an expansion of those statutes where if somebody's acting in the course of their duties and you engage in an assault on that person in the course of their duties, you can be charged with the heightened level, because assault 4 is generally a misdemeanor, Class A misdemeanor. This is expanding it to a C felony under these specific circumstances.
Interesting. Okay.
Any other questions? Senate Bill 243, this is possession of a firearm within the Capitol Airport passenger terminal, public building subject to certain policies or school grounds. This one's simply, it's a Class A misdemeanor, and it simply just added language within a building subject to a policy described in ORS 166-377 to the description of the offense. And so it's essentially, the recommendation is no crime category, no person crime. It is just a modification of the statute. It didn't add to anything to indicate a need for classification of a crime category or a person crime. And this one is HB 4041. This is on 2 slides because I could not fit this into one with the amount of text. So I apologize. This is a Class C felony. It does have quite a big summary, but again, you do have that document if you need to go through it, or I can pause here if you need.
How is this different from the existing statute? Attempt to elude.
Take this one specifically, and it's been unfortunately over a month since I've been. I don't remember exactly how it differed.
I can find out if you need me to.
That's okay. We can keep moving.
If I recall, and again loosely, it expanded in the areas that you see here as kind of the recommendations built off is related to repeat offenses and or the levels of entry that were of the action. I believe so it was an enhancement to the existing crime for those particular circumstances.
Yeah, to add to that, it does say section 3. I believe that this is new text to the bill in the summary. So that's what was added to it.
Actually, that's the existing statute already.
Oh, okay.
That had already existed.
Okay.
I think Ryan was correct that what they did was they created some additional enhancing factors that ultimately needed potential aggravation of crime classifications for it, recognizing that there were circumstances in which it could become ever more dangerous behavior.
So the language that in this one then is a police officer who is in uniform and prominently displaying the police officer's badge is the original. And then I think it, like you said, yes, it does kind of that language as it goes through these crime categories. the behavior is what the recommendation was based on, kind of changing that through. The crime category and person crime were already established in this bill as well. So. Any questions on this? Chair Solomon, you don't have any others? House Bill 4089, non-payment of compensation of employees and independent contractors. This is a Class A misdemeanor. The recommendation is no crime category, no person crime, and this is aligned with other non-payment crimes. And then same bill, non-payment of compensation of employees and independent contractors. This would elevate it to a Class C felony. It elevates it to a Class C felony if a direct contractor or subcontractor knowingly enters into a contract with a construction labor contractor who is required to be licensed. This was the subcommittee recommendation is a crime category 1 and no person crime designation. The reasoning for this is very sort of a similar public assistance fraud is the closest comparable crime and is a crime category 2. Knowingly entering into a contract without proper license is less serious, and so the crime category should be lower. And so that was the reasoning for this recommendation. So in your memo, I did note that there was one bill that the subcommittee has 2 options for recommendations, and so this is where kind of as a whole we, along with the rest of the recommendations, we do need kind of the commission to come to a conclusion for this particular bill that came through. So I do have an option A. I do have a slide with option B. Again, you do have these 2 differences in the document and the memo that I gave you. So I'll go over this one first and then go over kind of option B. And if any of the subcommittee members would like to chime in on either, I think that would be incredibly helpful. I do know that when we had this conversation in the subcommittee meeting, it was a really good conversation. It was just came down to kind of language. And so bringing it here for you all to make this decision today. So option A, this is HB 4151. It's initiating a false report that causes enhanced law enforcement deployment. This is a Class C felony. And so this recommendation is that it is designated a person crime, and it would be crime category 4 or crime category 6, depending on injury level. And so crime category 4, if it's serious or physical injury, and crime category 6, if death did occur. And so if you look at the language in the summary, it does say it's a Class C felony if the false report is of such a nature that the person initiating the report intentionally causes the deployment of an enhanced law enforcement response and recklessly causes serious physical injury to or the death of another person as a result. And so this particular recommendation is to kind of break those up, the physical injury or death of, into 2 different crime categories. And so it's based on that language. The reasoning for these 2 particular recommendations is that it would disproportionately affect younger people at higher rates. If they were ever charged with this, it would be from an injury, not from a death. The reasoning is that if a death did occur, they would then be charged at a higher crime, a different type of crime. And then they compared crimes with a similar mental states, particularly manslaughter 2 with reckless mental state and assault 2, and then bumped it down by 2 levels because a false report is less severe than the act directly. So this is one of the recommendations. Are there any sort of questions on this one?
I have a question more about just the word or a word intentionally. When it's you're prosecuting somebody for intentionally causing the deployment, does that then exclude, say, individuals who might be mentally ill, believe something's happening? It leads to an enhanced law enforcement, like a delusional person who might believe someone's breaking into their home, leads to an enhanced law enforcement response where then something goes south and somebody.
Yeah, so with regard to mens rea, the mental element of any crime, we kind of separate whether or not there's mental things as potential defenses that may exist to it. Really, the mens rea here intentionally, I always think of intentionally as purposeful. That you're acting purposely.
Meant to do, you wanted to cause that.
You're trying to get law enforcement or EMS response as for what you're doing. And the mental aspect of it plays kind of a side role in that we then go into the whole mental defense side of it. Carl, can you think of a better way of explaining it?
I mean, I'm following you, of course, but I mean, I think that intentionally means that you intentionally desire that action. And if you did so in a diminished capacity, or you had a mental health issue or other issue, then you'd have a defense that you didn't intend, that wasn't your intent.
This is just my ignorance on this side of the things.
The mens
Yeah,
rea aspect.
Yeah, the way I'm trying to think about this crime, I think we struggled with this a little bit. I'm certainly struggling with how this would ever be charged. And trying to think of a situation where it'd be charged, I mean, the best guess I could come up with is that an individual calls in and says there's a school shooter at a school, and that they intentionally called that in knowing there wasn't a school shooter. So they intended to get a higher level of law enforcement response, knowing the serious nature of a school shooting, knowing it didn't occur. And then the recklessly causing a serious injury or death is complicated because does that mean the police officer maybe was speeding to get to the location and ran a red light and hit somebody, and that's a reckless causing serious injury or death? Or the police officer responds and believes there's a school shooter and sees someone they believe to have a gun and they shoot that individual and they didn't have a gun? I'm struggling with how this would ever be charged, but I hope that's helpful in trying to think about this, the two options, A and B. I have more to say on option A and why I think that's the appropriate between the two, but I'll wait until that time is appropriate.
Yeah, Chair Solomon, I was going to ask that. Do you want me to go through option B and then open it up for subcommittee members?
Yes.
Okay.
Yeah.
Sure. So option B, again, it gets down to language. Everything is the same. This is just the recommendation is that it is a person crime, but it is a crime category 6 or crime category 8, depending on level of injury level. And so crime category 6, if there is serious physical injury, and a crime category 8, if there is death. And so those are the differences there. The reasoning here is that it aligns with other crimes dealing with recklessly causing serious physical injury or death. Those are at crime category 8 or higher. And then it, again, with this, you're challenging victims to be content with presumed probation if there is a lower crime category. And so those are the two options. I can't show them at the same time, but I can toggle back and forth if you need me to. But Chair Solomon.
So to be clear, there was consensus on all of the other recommendations.
Correct.
And it's really this one here where there was a little bit of difference and we've got two different options. So I would love to hear more from the committee members around their thinking and why one option is better than the other to help inform the commission's decision. I don't know who wants to start.
So in the interest of full disclosure, I'm the option B guy. We're option A.
Okay.
So I don't know if you guys would rather hear justifications for option A and then go to B, or I'm happy to explain mine for it. Perfect. So initiating a false report has existed forever. It's typically a Class A misdemeanor. What the legislature was trying to do, and I know because ODA was a big part of this effort, was to address those swatting efforts that exist out there that have created some dangerous circumstances, not only for law enforcement and medical personnel who are responding to these things, but ultimately to the people that they then interact down the line with. And so they created this additional enhancement to a C felony if the false report is of such a nature that the person initiating the report intentionally causes deployment of an enhanced law enforcement response and recklessly causes serious physical injury to or the death of another person as a result of that enhanced law enforcement response. So the intentional act here, the purposeful act, is that they're trying to get an enhanced law enforcement response to this. But at the same time, they are also responsible for having a reckless mentality as to the threat of serious physical injury or death. And recklessness in the state of Oregon is a person is aware of and consciously disregards a substantial and unjustifiable risk that a result will occur or that a circumstance exists. So that's the mentality that a person's ultimately going in with here. To me, even, and we can talk about impact on children and things of that, but a level 8 is at the level where it becomes presumptive probation on the grid block. The first 3 the criminal history scores for that ultimately place it in an optional probation route. So the court has the ability to ultimately depart that person under certain criteria. They can do it anyway from any of the potential prison blocks, frankly, for a number of reasons. Under certain circumstances. I find this to be most analogous to the failure to perform the duties of a driver when people are injured. So hit and run, which is what failure to perform the duties of a driver statute is generally a misdemeanor unless in the collision with that person's vehicle, they know or should have reason to know the other person that they struck with their vehicle has been injured. Then you have heightened obligation. It becomes a C felony there that is subject to enhanced potential penalties. And the standard for a C felony, meaning you left the scene without providing your license or trying to call for help or anything like that to those injured people, is a crime seriousness level 6. However, if death or serious physical injury occurs, it becomes a crime seriousness level 8. So we're dealing with this kind of a similar situation here where because of the enhanced law enforcement response that they've called for intentionally as a part of this new swatting provision of initiating a false report, and the person's recklessly creating a scenario in which serious physical injury or death occur, to me, it makes a lot more sense for it to ultimately be a 6 and an 8, depending upon the circumstance. I looked at other statutes. Assault 3, for example, is to one theory of assault 3 is to recklessly cause serious physical injury to another person by means of a dangerous or deadly weapon. That's a standard of 6 normally, but it becomes a level 8 if it's by a motor vehicle. If you intentionally or knowingly cause serious physical injury to another person under assault 1, it's a crime classification 9 as the standard and can become a 10 if the victim didn't substantially contribute to the commission of the offense. For me, where this really came down to is imagine a circumstance wherein I'm thinking of this through my prosecutor's lens. It's going to seem very unsatisfactory for many victims, whether it's family of our law enforcement officers, EMTs, or the person that they ultimately killed, because in the scenario of a school shooting, officers come in with guns drawn, come around the corner and somebody's engaged in some furtive movement that causes them to be concerned and they fire a gun and it turns out to be a student or teacher just trying to flee the situation, to then have to explain to that victim's family that this is a presumptive probation sentence, no matter, until the person has had 4 or more non-person felonies on their criminal record. And it just doesn't comport, from my perspective, with what we've done elsewhere in felony sentencing guidelines anywhere else here. So that's my kind of thought process. Carl brings up the fact that, his concern is that children are going to primarily be the people that ultimately could be the ones ultimately punished for this. And that, I totally understand that logic. It makes a lot of sense. In fact, he's probably right on that. We do have Senate Bill 1008 here, which significantly restricts the prosecutor and the court's ability to punish children already, requires a hearing for us to treat them like an adult, where we have to demonstrate essentially higher sophistication than ordinary to get them into adult court today, when we didn't have to in the past. And it's exceedingly rare. We've only had a handful of instances since Senate Bill 1008 has passed where courts in the state of Oregon have treated children who've committed very serious crimes as adults. So like 4 or 5 total. So it is exceedingly rare, which means they're going to be subject to juvenile courts and the juvenile court punishments, is my mindset on these cases probably every time. So that was kind of a window into why I liked option B better than option A. But they have good arguments from my perspective in support of their option as well.
Great. Carl, Amy, you want to chime in?
Yeah, I probably was the one on the fence between the two. I looked at Commissioner Prost is correct, right? That option B, given the severity of the injury or the harm, would be consistent with our sentencing guideline framework. The reason why I guess I was leaning toward option A to the extent that I was is, first of all, this is really complicated. We were talking about the mental states, and it's really hard to even figure out how this could work. But at the end of the day, the distinction between, say, this one and say the failure to perform duties, right, that Commissioner Perosa was talking about, is this is a phone call. This is 2 steps back from the harm, right? It's not like a person is directly there. And I guess that's what was persuasive to me, looking at the conduct itself and the culpability there. But I certainly understand the other side of the coin, right? So that's why I landed kind of where I did. But we thought that this group, with all of your perspectives, would be the best place. Y'all could have a conversation and then try to figure out what made the most sense.
Carl?
Yeah, thank you. So I believe option A is the appropriate choice. Regarding hit and run and assault, in those 2 scenarios, the person who is ultimately convicted of the charge actually committed the assault and the hit and run. They're the person who actually caused the harm to the individual. And that's not what the statute says, and not what it punishes. So I think that's a really important distinction. I do believe younger people are going to be charged disproportionately with this crime, to the extent it's charged at all. I'm still having a hard time seeing this really come up, but if it were to, I think it's disproportionately younger people in Oregon. It's not necessarily the age that you allegedly commit offense. It can be when you're charged. So if you allegedly commit this offense when you're 16 or 17, but you're not charged until 18, you're going to adult court. So it's something to be aware of. In many states, that's not the case. It's what the age you were when the alleged crime was committed. But I think the other important thing to think about is this. If you think about the homicide statute and the mental state for it, murder in the 2nd degree is intentionally causing the death of another. Manslaughter in the 1st degree is recklessly causing the death of another with extreme indifference to human life. Manslaughter in the 2nd degree is reckless. So manslaughter in the 2nd degree has the same essentially mental state as this statute does when it talks about recklessly causing physical injury or death of another. Manslaughter in the second is a level 8. But in this scenario, you're not the one who actually caused the serious physical injury or death. You made a phone call, and then there's an intervening act which actually resulted in serious physical injury or death. And I don't believe it's justifiable to have this at the same level of assault or manslaughter in the second degree when you're not the one who actually committed the serious injury or physical death. So the thought was to reduce it from assault or manslaughter for those reasons. And that's why we kind of compromised down to 4 and 6. I mean, I think there's an argument it could be even lower than 4 and 6, but it was somewhat of a compromise to say 4 and 6 for physical injury and death. And that's really the justification and why I believe option A is appropriate. And I'm happy to answer questions or discuss it further if anyone has any.
Buttle, other questions, comments?
If I need to go back to the other slide, let me know.
I'm just curious. You mentioned this doesn't happen very often.
Well, that's where we spend a good deal of the time trying to talk through scenarios where this could come up. You know, somebody sends the Coast Guard out on a very stormy night to ultimately deal with a boat that's overturned, but there is no boat. There never was a boat that was out there, and the chopper goes down and people die as a consequence of that. You know, it's hard to envision scenarios in which this will come up. But nonetheless, the legislature passed this bill because there was concern. There are circumstances that are arising that they felt needed to be addressed. So.
And can I respond briefly to that? Because I agree with Commissioner Perosa. That was another scenario we discussed. And in my opinion, I'm not a prosecutor, but that's different to me than a school shooting situation. Because if you call the Coast Guard on a really stormy night to go save a boat that doesn't exist, there's a really strong argument that's just reckless in and of itself, and that you would be charged with manslaughter in that scenario, rather than making a phone call saying there's a school shooter where you wouldn't expect a death or serious physical injury resulting from making that phone call. But you could, and a prosecutor could make, I think, a compelling argument, depending on the circumstances, that sending someone out into a stormy sea, that is reckless in and of itself. I hope that makes sense.
But Carl, don't you agree that under the school shooting scenario, where say law enforcement goes in and shoots somebody in the school, arguably a prosecutor could charge that person that made the phone call to begin with, potentially with manslaughter too anyway, and that initiating a false report just requires the prosecutor to ultimately prove more elements. So it's actually has more that the prosecution has to ultimately present to ultimately get that conviction.
Yeah, I understand your argument, but that, to me, that even is more justification for having option A. Because if a prosecutor can charge a manslaughter in the second degree, then they have a crime serious level 8 already potentially there. And the actual phone call itself is almost like a lesser included. It's a different offense, but it's a lesser offense than the manslaughter. So therefore, the crime serious level should be less.
Yeah, I don't know if I agree with that. I'll just say.
So again, we're all on this commission from different points of view. I happen to live through a pretty traumatic shooting at our community college. So I happen to know our law enforcement and EMT folks all trained constantly now because of that. And the likelihood of what you just described and the amped up response that might occur is a real scenario that could happen. So I agree with you. The seriousness of it is, even though, clearly the person making the phone call isn't creating or causing at the point of somebody getting hurt or killed, they certainly are initiating it, and it is a serious thing. And that may be different places in the state, but from my point of view, it's pretty damn serious.
Right. And the thing about hit and run is, yes, they might have caused the collision that ultimately, or they don't even, they had to have been a part of the collision that ultimately caused injury. But what we're punishing with hit and run is the failure to stop and provide some assistance to the person that ultimately has been injured as a consequence of the collision that occurred, right? That's the part we're punishing with the hit and run statute. It's not the collision part of it itself. So the idea that you had to be hands-on isn't necessarily what the legislature is intending to penalize in that scenario. It's really the failure to perform additional duties to them. Potentially call EMTs or law enforcement to come and save that person's life.
Right, but I think that's the important part though, because you caused the injury and then you didn't do your duties as a driver to call and get that person help, which could lead to their death, which is why it's at that level. I certainly believe school shootings are extremely serious, and I wouldn't want anyone to think I don't, because I do. I'm just trying to differentiate this statute because the individual who makes the call isn't the one who killed the person. They're not. And so to treat them the same as an individual who killed somebody, I just think is inappropriate. I don't think it's consistent with the sentencing guidelines at all. And therefore, someone who actually commits the crime of manslaughter and directly causes the death of another should have a higher crime serious level than someone who makes a phone call. And I'm not diminishing for 1 second how serious a school shooting is in making that analysis.
Yeah, I guess I'm trying to get a clarification out here. I mean, making false reports has been people do this all the time, right? So the key here is the enhanced law enforcement, right? So in this, I got 2 questions here. Number 1 is, are we assessing the individual's belief or desire to initiate enhanced law enforcement when they make this false report, right? They're trying to get a large-scale police response to this, right? And this comes back to Carl's argument about, when would this actually happen, right? We would have to do something like there's a school shooting going on. There's something really substantial to do this, right? Versus what would happen if somebody made a false report and the police on their own decided we're going to send enhanced response to this, right? Let's say they call and say somebody's barricaded themselves in their house and they've got a gun, and the police decide on their own to send the enhanced thing, right? To me, that feels different, right? It feels different when somebody's trying to say, I wanted that over the top police response. Over the top's not the right word, but they wanted that extreme response versus somebody who got the extreme response but necessarily didn't want to.
And all are elements, to be clear, the crime that has to be proven before a judge or jury.
Yeah.
They have to intend an enhanced law enforcement response.
Yeah.
And, been aware of and basically consciously disregarded the likelihood that death or serious physical injury could occur as a result of that.
It's high burden. Yeah, I'm not an attorney, but it feels like high burden.
So I want to do a time check here real quick because I start to twitch when meetings go over time and we're getting close to 3:30. So I think we have a couple of options here. One, and I want to check in with you, Brian. One, we can just finish this item up and kick the burn skip prioritization to the next meeting, but I'm not sure if that's a problem if we do that. 2, we could take a little more time and maybe go till 3:45 and get out of here if everybody's willing to. And I'll do my best not to start freaking out. But let's make a decision about that. So Ryan, do you have thoughts?
I would just ask if we could get the skip input on the skip decision, we could probably shorten the presentation and really get to what we're asking. But it would be good to get that because so the decisions are made before applications are received, which is the closing date of tomorrow.
Okay, how are people with staying a few extra minutes?
Sure.
I can stay as long as needed.
Okay, and I'll suck it up here because I feel like this is an important conversation. All right.
Chair
yes.
Solomon,
Yes.
Commissioner here. I might also behoove us to, if we have agreement on most of the others, I do have some issues with the fentanyl. I'd like some more information, but if we're in agreement with on most of the others, maybe we approve the ones that we're all in agreement on and then table this for next meeting.
We could do that. I mean, so there was consensus and one, I really want to acknowledge the committee, the fact that, you know, we've got people from different ends of the system working together and had consensus on literally everything except for these two. And I feel like there's really meaningful, you know, differences is commendable. So I actually think that's a good idea, or unless you have a problem with that, right?
There is a hang up with that. We need to have these determinations made so that we can submit our final.
Okay, then let's power through with this. Let's go ahead. We've heard from both parties, unless there's, all three of you, unless there's anything else you want to add, I suggest that we vote on option A, see what we get, and then vote on option B, or vice versa. Okay, is there someone willing to make a motion to approve option A?
I'll make that motion, Commissioner McPherson.
All right. Is there a second?
Commissioner Norton seconds.
All right. Roll call, Jenny?
Commissioner Beach,
Yes.
Commissioner Freeman,
No,
Commissioner Harris,
No.
Commissioner Lehman,
No.
Commissioner McPherson,
Yes.
Commissioner Norton,
Yes.
Commissioner Perosa,
No.
and Chair Solomon.
Yes.
So we have 4 yeses and 4 no.
Okay. So
Challenging this was?
So I imagine when we do it the other way, we're going to wind up in a
should
deadlock.
try it, right?
Okay, well, let's go ahead. Okay, someone
Move to approve
Yep.
option B.
Okay, great. We have, okay, motion made, seconded. Roll call, please, Jenny.
Commissioner Beach,
No.
Commissioner Freeman,
Yes,
Commissioner Harris.
Yes.
Commissioner Lehman,
Yes.
Commissioner McPherson,
No.
Commissioner Norton,
No.
Commissioner Perosa,
Yes.
and Chair Solomon.
No.
jeez.
That Paul, or sorry,
Go ahead.
Chair Sullivan, are you the deciding vote since we have a tie vote?
I don't think so.
We're short of A.
Yeah, I don't think, I think that would give me a double vote. I would feel uncomfortable making a unilateral kind of decision at this point. Okay, we can bring this back up when we have another voting member, so.
I might suggest we could try to schedule a meeting specifically for this, ideally for us before the 31st of the month, so we can submit our LC, where we could get all 9 voting commissioners together
Okay.
on this matter.
Would it be helpful to approve the rest of them?
Yeah.
Yes, absolutely.
Good.
Yeah, thank you. Specifically to this one.
Can I just ask, is there any other information that you want presentation wise? Can I, so for sake of the third time having to make these arguments, can I put together, use the language that they've had in this meeting, put together language for
Yes,
slides?
I think that would be really helpful.
Okay, a little bit more detail.
Yeah, a little more detail.
Okay.
And if Amy, Carl, you guys want to, Chris, want to provide more information, help us think about this, that would be great.
So I'll have a more detailed presentation of both sides based on the
Yeah.
discussion today.
Okay, so now I would look for a motion to approve. Oh, go ahead, Commissioner Miller. Do you have a question?
Thank you, Chair. I just had a question for Ryan. I know that you're under a deadline to get the LC done. Is it possible to just draft 2 versions, one that has the A option and one that has the B option? That way, if you can't get the meeting scheduled, or that gives us a little flex time to find time to meet.
Yeah, I think there is a contingency option. And like I said, it would be ideal if we could just drop this in like a 30-minute online meeting this
Right.
month, but there is a contingency that we
Okay.
could explore.
Okay. And while I have the floor, I also just want to give a shout out to Rachel, who did such a great job walking us through this and providing us this information in advance. So it made it really easy to be prepared for these meetings. So thank you.
No, this was the easiest meeting I've ever had, so I appreciate you all coming.
Nice.
Sure.
All right, is there someone willing to make a motion to approve the remainder? And I don't know how you would like us, any particular language, Rachel?
I have that language. I did not include I
Okay,
did not include this bill
okay, so let's
language, so you might
that
want to.
language back up, please. Okay, so if someone's willing to approve the subcommittee's sentencing grid modification recommendations with the exception of House Bill 4151.
I'll move.
Is there a second?
I'll second.
Okay, motion made by Commissioner Lehman, second by Commissioner Harris. Roll call, please, Jenny.
Commissioner Beach,
Yes.
There's no one in your contacts named
Commissioner
Commissioner
Freeman.
Harris.
Commissioner Harris,
Okay. He's got her in there as her nickname. So you guys know.
Commissioner Lehman,
Yes.
Commissioner McPherson,
Yes.
Commissioner Norton,
Yes.
Commissioner Perusa,
Yes.
and Chair Solomon.
Yes.
Passes unanimously.
All right. Let's quickly talk about the burn skip prioritization.
Beautiful. Let me just go ahead and pull up the slides here, everyone. Just give me a moment while those load. And this should be fairly quick, so hopefully I don't take up too much of your time this afternoon. Okay, can you all see the slides?
Yes.
Yes, perfect. All right. Well, good afternoon, everyone. For the record, my name is Kylie Russell, staff here at CJC, and I'm here today just to discuss the burn skip program priority areas and whether you all, our commissioners, would like to place prioritization on one or more of these areas during the application review process, which is coming up. So we'll go ahead and start. I just want to really quickly highlight just a few key details from the solicitation. So it was released May 22nd and applications are due tomorrow by midnight. So we're really excited to jump into that application review process. We've seen most of this information before, but I do just want to quickly highlight two key details, those two bottom bullets. So for program eligibility, in order to become eligible for funding, all proposed programs must have a direct connection to crisis intervention. And so this is something that staff is going to take into consideration and will evaluate during the review process. Additionally, CJC is required to adhere to several pass-through requirements at that federal level, including the local units of government requirement and the less than $10,000 jurisdiction pass-through requirement. And so those will also be considered during the evaluation. Okay, and I'll just jump in here. So as staff prepares for the application deadline, we've developed the following process to evaluate applications. So first, staff will analyze the eligibility of each program by determining whether there's a direct connection to crisis intervention. So we'll need to just ensure that there's a focus on identifying risk and intervening before harm occurs. And so applicants that don't meet this crisis intervention eligibility threshold will not be able to move forward for funding consideration. Second, staff will then give priority to applicants that meet the direct local pass-through requirement and or the less than $10,000 pass-through requirement established by BJA. So those two pass-throughs there. And then third, staff will then score each application based on their adherence to the application criteria and BJA approved goals and program priority areas, which we'll review next. So this is just a three-step evaluation process in how CJC staff will evaluate our burn skip applications. Okay, And so as a part of the application review, the 3 burn skip priority areas will be included in the overall application score. So, but before staff can begin their evaluation process, the commission has the discretion to determine the prioritization of the burn skip priority areas just to assist staff in their overall analysis. So those priority areas are listed here. They've also been outlined in those memo materials that you all have. So with these 3 priority areas in mind, I'll go ahead and just jump to the 2 options that were outlined in the memo materials as well. So we have 2 options for your consideration today. So to assist staff, the commission may consider option A, which is to decide to weigh all 3 burn skip priority areas the same during the application review and analysis, or consider option B, which is to weigh 1 burn skip priority area or 2 over the others during the application review and analysis process. So option A, weighing all 3 the same, B, weighing 1 over the others, essentially. And so this will actually bring me just to staff's recommendation. So with applications being due tomorrow, we don't really know how many applications we'll actually receive, nor what types of programs will be seeking funding. And so with some of this information in mind, staff recommends moving forward with option A, just to weigh all 3 priority areas the same during the application and scoring analysis process. That starts later this week. So Chair Solomon, I'll turn it over to you. I'm happy to answer any questions if you all have them.
Great. Hopefully this won't be too difficult. I'll just share my thinking. On the one hand, I could see us prioritizing number 1, which is much more action oriented. And that seems like a good prioritization. I also understand staff's concerns. They don't know what the applications are going to look like, probably give them a little more flexibility. So I think we could go either way here.
I am curious, we don't have an obligation to share the prioritization prior to applications being received. I just think about somebody who's written grants and applied for these types of things. If I knew that there was a priority, I would likely gear my application to meet the priority population is how I typically do that. So that's the only, I agree with you though. If that were up to me, like, but it may it's up to me partially. I would prioritize 1. I do think that is more in line with what we would want to see, but I also have concerns about people not knowing that that was the priority.
I'm just going to say that you're correct, Julia, that no, that was not messaged in the solicitation. Decision being made at this juncture prior to.
But even if we prioritize number 1, it doesn't mean that someone that came in with an application that focused on 2 or 3 couldn't get funded.
But they would be less likely to get
Right,
funded.
exactly.
It just would come down to that pool of scoring. As we've seen a number of our competitive grant programs. So that's why we wanted to at least establish something going into that application review, kind of to the points you made, Commissioner Harris.
Commissioner Norton.
Yeah, I would concur with, if we were going to advertise them, that should have been done when we did the grant announcement versus now. I think it really does impact how people write their grants. So I'm all for option A for that reason.
Okay. Is there someone that has a strong desire to go with option B? Great, let's vote on option A. And what might be helpful is after we get through this round, I think we could, if there's a next round of funding, prioritizing, because I do think it makes sense for these dollars to be more focused on the programs that are doing the work rather than trainings. But for the sake of this grant award application, or this grant application process, sounds like we have a desire to go with option A. So Commissioner Norton, would you be willing to make a motion then to that effect?
I will move to weigh all 3 priority areas the same during the scoring and analysis process.
Great. Is there a second? Great. Motion made by Commissioner Norton, second by Commissioner Lehman. Roll call, please, Jen.
Commissioner Beach,
Yes.
Commissioner Freeman,
Yes.
Commissioner Harris,
Yes.
Commissioner Lehman,
Yes.
Commissioner McPherson,
Yes.
Commissioner Norton,
Yes.
Commissioner Peretza,
Yes.
and Chair Solomon.
Yes.
Unanimously.
Beautiful.
right.
Thank you all.
Thank you. Okay. Quick agency updates.
I will save you the time. I'll just let you know that we are working on, obviously our next round of updates related to 39. And so our primary focus this round, so like each odd month, right, we do an update this round to focus on the data book. We give a little more specificity in the data we'll include in that book. So I can share slides with you all at a later date or certainly catch up in August on that point. That's the status 3069. As mentioned prior, agency budget is coming together, be submitted at the end of the month. And so anticipating August, we will give you the rundown of our, particularly our POPs and current service level grants.
Great.
That was it.
Super. Good meeting. Thank you again, Holly.
Thanks for coming, everyone.
Appreciate hosting.
Of course.
Great. We are adjourned.